Hi everyone, it's me again, Anja from Anja Opperman Attorneys in the north of Johannesburg. So you already know that we specialize in family law, but we also do loads of general litigation. Now, the number one complaint that I've received from clients is that attorneys use way too much legal jargon. What they are telling me is that basically they struggle to understand two words that come out of our mouths. And then we also love sprinkling that in with a little bit of Latin, which of course they made us study, so of course we like doing that. The surprising question that I get more often than not is, what is litigation? And if you don't know that, it means you're a lucky person because you never felt like you needed the court's intervention to exercise any of your rights. And also you haven't been approached by another party who feels that they need the court's intervention to exercise their rights against you. That is basically when litigation comes into play, and that is when you would phone a lawyer to navigate you through this complicated process. Now, just to break things down a little bit, there are two options in terms of approaching a court in South Africa. There are, of course, many different courts. You have to make sure that you go to the correct one. You can't forum shop and decide. Sometimes you have an option between one or two courts, but you firstly need to make sure that you are in the right one. Then secondly, you need to know whether you are going to be following action proceedings or application proceedings. And there is quite a big difference between the two. An action is brought on a summons, and the summons is a document that sets out the basis of your claim. Now, I've got many clients who have a very strong opinion on what they want to have included in that summons. But the first thing I always explain to them is that obviously your lawyer will draft this document in accordance with the standards of our legal system. And that entails that if the facts form part of the cause of action in the matter, they will be stated. But if it's a supporting fact that just strengthens that idea, it will never be included in the summons. The reason for that is that on action proceedings, we are going to be in front of the court, and what I will do is I'll put my witness in the box, and then I will ask you for all of those other supporting information and the supporting facts which strengthen the main facts of your cause of action. A good example of this is that the summons will say that on 17 February 2026, you entered into a written agreement with Mr. X. That is what we put in the summons. We will not state there that that morning you were driving around town and you were in the market for Mr. X's services and you saw his advert board on the road as you were driving, and right there and then you made a decision to pull over and go have a meeting with him, and he really impressed you at the meeting, and that is why you signed the contract. That information might or might not be relevant depending on exactly what your case is, but even if it is relevant, we would not include any of that in the summons because that's the information that you can give court when you are doing your oral evidence during the trial of the matter. If we are looking at any documents, the main document, like the contract in this instance, would be attached to the summons, but there might be a number of other emails, correspondence, a documentation, a copy of the advert of the services that you could refer to, and those become part of your bundle that you rely on when you bring your evidence. And there is a process to exchange all of those documents, put them neatly in a bundle, discover them to the court, and make sure that you are following the correct process. Now, a good lawyer will always take a look at all of that when drafting the summons, because we need to make sure that our supporting facts do actually support the cause of action that we're disclosing, and make sure that our cause of action is provable when we look at the supporting facts. So a lot of homework goes into that document, but when you look at it, it seems quite short and it seems like a summary of the matter, and that's for a very, very good reason. Now, on the other hand, I've referred to the application process, and that works very differently. In some instances, you can approach the court on a notice of motion, and in the notice of motion, you state exactly what you want. We do this for certain relief that we need. There are certain matters that are always brought on application proceedings. And the other instance where you can use it is if it's not foreseeable that there would be a material difference in fact between the applicant and the respondent's cases. Because now we don't have to put that witness in the box. It's not necessary to bring the expert witness to come and tell us about the general damages. We have a very certain set of facts. It might look different, the respondent's affidavit might look a bit different, but materially, when we look at the matter, the two do not differ that much, and it's more of a legal point that needs to be argued to see, was the applicant right or was the respondent right. In those instances, we file the notice of motion, and then we attach to that a founding affidavit. Now, the affidavit is very different from the summons in that here you are giving your evidence. So you will go into a lot of detail, and you should here present your case and write all of the information. You could include the story about how you were driving down the road when you saw the advertisement for Mr. X's services. Because in this instance, you won't be in the box. If all goes well, your advocate or your attorney will, on the day of the hearing, present legal arguments and factual arguments and refer to that affidavit as the evidence. There won't be any witness in the box. Any documents that you want to rely on need to be annexed to those affidavits. The papers are thick and lengthy, but that's it. Now the court can take a look at what you're saying. It can evaluate the affidavits and the documents attached to the affidavits of the other side and make a finding. The interesting question is, what happens when the applicant did not envision a material factual dispute and then it does arise? The respondent's affidavit shows up and the information in there is just completely different. It's like chalk and cheese, and we don't actually know now, are we dealing with this kind of matter or that kind of matter? Under such instances, the court can make a ruling to convert the application process into a trial, and it can still hear oral evidence. And if that happens, you basically end up with an action proceeding, even though you started out with application. There are many interesting things around this topic. Each process has different timelines and different requirements. As legal representatives, we are experts and we can advise you very closely on all of that. If you would like more information about litigation, please like and subscribe and follow us for more information.